The broadcast is now starting. All attendees are in listen-only mode.
Good morning, everybody. I'm Pat Jones, the Executive Director and CEO of IBTTA. I'm pleased to welcome you to today's webinar to discuss the U.S. Securities and Exchange Commission's Municipal Advisor Rule and Municipal Continuing Disclosure Cooperation Initiative. We have over 40 people registered for this webinar. I want to especially recognize Nick Grieshaber of the Pennsylvania Turnpike Commission, who organized the speakers and put the content together for this webinar. Thank you very much, Nick. Looking ahead, our last meeting of the year will be October 19 through 21, 2014. It's IBTTA's Global Summit, Innovations and Technologies for Sustainable Mobility, Environment, and Road Safety. And it's going to be held in Prague in the Czech Republic. It's not too late to register, so if you're interested, please register online on IBTTA's website, ibtta.org. If you're seeking professional development hours for this webinar, we're not able to give credits, but we're happy to give you a certificate for attending the webinar, and it's up to each individual to submit it to obtain the credit. If you'd like to receive a certificate after this webinar, please email Kathleen Davis at kdavis@ibtta.org. Again, that's kdavis@ibtta.org. Well, we're very pleased to have four highly regarded presenters today. Each are prominent in their respective fields. Each presenter will speak for about 8 to 10 minutes, and during the webinar and their presentations, we encourage you to submit questions via the Questions tab in the box on the right side of your screen. We will monitor these throughout the webinar, and the Q&A will follow all of the presentations. If you have a question for a specific panelist, please note that in your question. This webinar will last 1 hour. We'll post the slides and audio portion of the webinar on our website by close of business tomorrow. If we don't get to all the questions before our time is up today, we will submit all the unanswered questions to the panelists afterwards and post responses on our website next week. Well, now it's my pleasure to introduce Nick Grieshaber. He is the Chief Financial Officer of the Pennsylvania Turnpike Commission, where he served there since June of 2008. Before that, he held positions of Director of Treasury Management and Treasury Manager. Before joining the Commission in 2000, he was a Finance Manager and Portfolio Manager for ADP Capital Management, Assistant Treasurer for BTR Dunlop Finance, Cash Manager for Silo, Inc., and Investment Analyst for American Life Insurance Company. Nick is the Chair of IBTTA's Public and Private Finance Committee and Chair of the Finance Committee for the EasyPass Group. Nick, you have the floor.
Well, thanks, Pat. Both the Municipal Advisor Rule, or MA Rule, and Municipal Continuing Disclosure Cooperation, or MCDC initiative, are of critical importance to participants involved in the debt issuance process. Issuers, underwriters, financial advisors, law firms should all be concerned about recent SEC action in this area. Just yesterday, there was an article in the Bond Buyer about a regulatory panel discussion at the Bond Dealers of America annual fixed income conference in Chicago last week. The focus of the discussion was MCDC and how the SEC is trying to encourage an active dialogue with broker-dealers. Just about everyone seems to be focused on materiality for good reason, and today's presenters will discuss this and other issues important to their webinar's attendees. It is now my pleasure to introduce our four speakers. Leo Carvanja joined PFM to head the compliance team in 2011 as Chief Compliance Officer and Managing Director. He has over 12 years of experience providing compliance support to firms in the investment advisory and securities trading businesses, including equity, fixed income, real estate, direct property and REIT securities, and additional alternative investment strategies. Responsible for all regulatory compliance program efforts related to PFM's business activities and personnel, Mr. Carvanja assists PFM personnel or professionals with specific compliance advisory guidance and leads the PFM compliance team's efforts to develop, maintain, and monitor firm-wide compliance with appropriate policies, procedures, and regulatory requirements. Mr. Carvenia, prior experience includes compliance management positions at Prudential Financial, Deutsche Asset Management, and Reef Alternative Investments. As a member of the National Society of Compliance Professionals and the Securities Industry and Financial Markets Association, Compliance and Legal Society, Mr. Carvenia also regularly serves as an arbitrator for securities-related issues among the investing public and/or industry participants. These issues are heard and decided upon under the FINRA Regulatory Organizations Dispute Resolution Mechanism. Mr. Carvenia earned a BS in Finance from St. Joseph's University and a JD from Temple University School of Law. Next, Rebecca Lawrence is the Managing Director at Piper Jaffray, a leading middle markets investment bank where she serves as in-house counsel with responsibility for legal and regulatory matters, respecting underwriting, sales, and trading of municipal bonds and other fixed income products, derivatives, and commercial lending. Ms. Lawrence came to Piper Jaffray from another large municipal underwriter, and prior to that was a bond lawyer in private practice. Ms. Lawrence served as chair of the Securities Industry and Financial Markets Association's SIFMA Municipal Legal Advisory Committee and holds a MPA in Public Policy from Indiana University and a JD from the University of Minnesota. William Rhodes is chair of Ballard Spahr's Public Finance Department as well as practice leader of its Municipal Recovery Initiative. Mr. Rhodes represents issuers, broker-dealers, and investors in all areas of public finance with an emphasis on the offering of high-yield, unrated municipal securities. He regularly advises issuers, underwriters, municipal advisors, and investors in the evolving landscape of municipal securities, regulation, and enforcement. Mr. Rhodes graduated from the Dickinson School of Law of the Pennsylvania State University and is admitted to practice in Colorado and Pennsylvania. The final presenter is Stan Konitz. Stan joined the E470 Public Highway Authority as its finance director in May of 2012. In that capacity, he oversees all accounting and financial analysis functions, including issuance of new debt. Prior to his current position, Stan served as the Deputy Manager of Aviation and Chief Financial Officer at Denver International Airport, a department of the City and County of Denver, after serving for 5 years as the Assistant Deputy Manager of Aviation. Prior to joining the public sector, Stan had a variety of marketing, contract administration, and accounting positions for companies in the Denver area. He is a graduate of the University of Northern Colorado with a bachelor's degree in business administration with an emphasis in accounting. He is also licensed as a certified public accountant in the state of Colorado. Leo, as our first speaker, I turn it over to you. Please be sure to take yourself off of mute.
Thank you, Nick. Thank you, Pat. And thank you, everyone, for joining. I'm very glad and pleased to be part of this panel and discussing with you today some of the key areas as it relates from a financial advisor's, municipal advisor's perspective, and for myself personally as a compliance professional, what some of the elements are for issuers, borrowers to understand and consider as it relates, for my focus, on the municipal advisory side of things. I really welcome this opportunity because I think this municipal advisory rule, we're now 3 months into the effective date, and you've seen perhaps a good deal of discussion, documentation, and perhaps some changes to the relationship that you may have with service providers, with underwriters, with municipal advisors, potentially with accountants, engineers that you may work with, as really the industry and the marketplace really absorbs and understands what this rule means and what it does not mean. I think some of the things that we want to cover today, I hope to really sort of think about what the questions that many issuers are left asking. And for the Q&A portion, I would suggest perhaps it would be beneficial to think about what questions you have yourself to share with the panel on these important topics. The rule itself is really set up to help categorize and I would say make more formal the roles of certain public financial professionals and help lead participants, including yourselves, to further establish clarity within transactions. I'll caveat today's discussion by telling you that many of the practical aspects of the rule are really not yet fully developed and continue to be worked on from a day-to-day perspective to really apply to the circumstances that you have as issuers and that many of the marketplace participants have from their organizational perspective. And we'll continue to see further guidance from the SEC and additional regulatory proposals for additional regulation from the MSRB as well as time passes. What I'm really saying to you is this is really the first phase in what likely will be months and years to come of additional regulation and additional clarity on what this rule means to folks who participate in this marketplace. So to give you some background and some context, I thought we would take a moment to really talk about the rule a bit and understand a bit more about why you might want to pay attention. When I think about the rule and leading up to the time as a compliance professional working within our organization to understand what the rule means for us and for our clients, there are some questions that continue to be asked. And to tee those up, I thought I would share them here with you, looking at how the rule actually affects issuers, the underwriters that they work with, and the municipal advisors that they employ. Looking at what the regulatory context, why did the SEC put this rule in place in the first place? What actions are possible for issuers to take in response to the municipal advisor rule? Although it does not regulate issuers, there are some real impacts and some real effects that I'm sure many, if not all of you, have felt in terms of perhaps the administrative aspects of putting together the required documents to assist the marketplace underwriters, financial advisors. What are the benefits intended to be for you as an issuer? And then importantly, I think, what are the new standards that begin to apply to municipal advisors? These are some of the questions that remain and some of the good questions that people continue to ask and focus in on. I think it's important to think about when we go through the Q&A portion of today's discussion. Many folks, including yourselves and many of the fellow presenters here and our colleagues and counterparts, are still facing the fact of going through the interpretive aspect and separating what's in the regulation, which is over 700 pages long, and understanding how it actually applies, what needs to be put in place, whether it's further documentation or further understanding of what the expectations are for a relationship or for a transaction, and trying to speculate as to how best to put in effect these rules and requirements for your benefit as an issuer, for the organization's benefit, and really also to meet the regulatory expectations as well. So that'll continue for some time, as we mentioned here. The SEC has tried to define in the release why these rules are really sort of in place from their perspective. As I mentioned, defining the category of who everyone is sitting around the transaction table is one area. Putting a regime in place that will allow for municipal advisors to fall under the SEC's jurisdiction is an important aspect of this. Putting record-keeping requirements in place for municipal advisors, and perhaps most key for the regulatory regime as well as for someone like myself in a compliance position, is understanding that the SEC will begin to examine and test for compliance independent municipal advisors, and FINRA will begin to test and examine folks who are duly registered as underwriters, broker-dealers, and municipal advisors. As I mentioned, the rule came into effect here on July 1st. Much of the summer, from a marketplace perspective, you certainly heard different terms and key areas thrown around potentially certification letters, IRMA letters. There are all sorts of things that were a natural effect of the rule becoming effective. The registration and the setup of each of these municipal advisors really kicked off in full effect as of July 1 and continues really through the end of October, when the final set of municipal advisors need to be registered with the SEC and the MSRB. So by way of background, the rule itself really set up the framework, and it included a couple of key areas that provided the definitions, the standard for what advice is and what it is not, and we'll talk more about that, and then also offered some exclusions and exemptions that would allow for folks to continue to provide recommendations and advice to you as an issuer without necessarily going to the SEC and MSRB and registering as municipal advisor. That portion of the discussion, the exclusions and the exemptions, we'll leave for Rebecca's portion of today's talk. But I think it's important and key for you to understand this rule really sets the framework for what is intended to be protections further for you as an issuer, as a borrower in the municipal marketplace. I think a lot of the things that you see happening right now between municipal advisors, underwriters, have really to do with making sure that we take into account the regulations as they've been expressed and understanding how best to make them work within the business that we all know and have been conducting here for some time in the marketplace, and trying to assess what the impact or the effect is. So if you've been having interesting conversations with underwriters, with financial advisors that perhaps have been more educational, I think that's a good thing from a compliance perspective. I think it's important for you as an issuer to be an informed consumer of these services, so to speak, so that you understand the roles, the expectations, and really the regulatory effect of what this rule means for folks. So let's spend a moment here to talk about what advice is. The municipal advisor is really focused on the person or entity that comes to you and provides you with advice as a municipal entity or an obligated person, focused in on issuance of debt or financial products. This is intended to capture those folks that prior to the rule coming into effect perhaps could walk in and give you advice or provide you with a presentation and did not have a regulatory requirement to be registered. Again, it's not focused on you as the issuer. However, it has implications for you because these are folks that you've worked with or wish to work with to provide you with that advice. The implications of being a municipal advisor really skim and focus in on those requirements to register in the first place, filling out the forms, filing the paperwork, but I think more importantly, looking at what the rule requirements are, building the compliance program to meet those rule requirements, and having the documentation for verification of the work that's done with you as an issuer. It also puts in place a fiduciary duty for anyone who's working as a municipal advisor and registered as a municipal advisor. They now, by regulation, by statute, must work in your best interest, must be sitting on the same side of that transaction table, providing you with advice, must give you certain disclosures, must be aware of certain conflicts. Those rules, those requirements continue to evolve as the MSRB really puts in place the additional standards, the additional requirements that are necessary for someone to conduct themselves as a municipal advisor. And this focuses in on the advice that you receive. Remember, the structure, the timing, the key attributes of the issuance that you're bringing to market. If someone's providing you with that type of advice or recommendation, the idea here is that they're either set up and structured in a way that they are registered with the SEC and MSRB, or they find themselves under some exclusion being able to continue to provide that advice. In all circumstances, you should know who you're working with and whether or not they are in fact registered and whether or not they in fact have some exclusion that they're relying upon. That fiduciary duty is something that should be in your mind as to who, it should be a filter as to who you're working with and thinking about so that you understand that one way or another. So by not providing advice, you put yourself in a position to act in a way that allows for you to not register. Importantly, you should focus on the fact that if you are a municipal entity yourself or an employee of a municipal entity, it's important to note, and I'll make the note here, among the exclusions, that's something that does not, if you actually make a recommendation or provide advice to a fellow municipal entity, another member of IBTTA, that's something that will put you in a position to do so without having to face registration. So I put this up here not for you necessarily to follow entirely, but I think this is some of the calculus that goes into thinking about whether or not you are being provided advice that requires registration, this is something from a compliance perspective we look at and focus in on whether or not the requirements are being met, whether or not it is in fact something that meets one of the exemptions, and ultimately looking at whether personnel need to be registered in the work that they do for you and the work and the conduct that they have out in the marketplace. So the piece that I've not focused too much on here because it's yet to come is really just to give you a sense of what's next. So we've made it through the summertime here, and the MSRB has been busy working on a couple of key areas that they're putting forward now that the rule has been established. First and foremost, I believe, is the standards of conduct and the duties for municipal advisors. These are the types of practical rules and requirements that will focus in on the disclosures that are made for you, what it means to be a fiduciary in the first place, focusing in on knowing you as an issuer, knowing you as a client, the suitability of the transactions that they make recommendations for, understanding whether there's a contract or not and the scope of that contract and the work that's conducted. These are all important elements from a regulatory perspective, not only from an evidentiary perspective, but also, again, focusing in on the regulatory intent, knowing that you have enough information to be informed about the services that you're being provided or any potential conflicts that may arise from the participants that are working with you. In addition to those areas, we're focused in on looking at supervision, putting in place a regime for there to be oversight, checks and balances within firms, within registrants. There will be a test for municipal advisors to take and prove that they have certain minimum qualifications to act on your behalf as a municipal advisor and work with you. There'll be, to a real sense, although many municipal advisors have their own internal policies, there'll be now a leveling of the playing field as it relates to gifts and gratuities, political contributions, if they have third parties marketing on their behalf. These are all areas that have been within the broker-dealer regime for some time and now rightfully are being looked at by the MSRB as to how to implement on the municipal advisor space as well. So I want to leave you with a few impressions from a compliance officer's perspective and from my viewpoint as to what some of the early indications of the implications have been around the municipal advisor rule. I think the key areas that have been focused on have been largely administrative to date, and there's been a good deal of sort of paperwork that's had to be done, as it should be from a regulatory perspective, to make sure that that's in place for review and for understanding. I think the regulators themselves, all of us as industry participants, really need to focus in on the clarity of the transactional roles, the transparency of the interests we all have in working with you, and frankly, the formality of the relationship that we have together. Municipal advisors are focused on and should be focused on acting in your best interest. I think underwriters and the entire municipal marketplace, including the financial advisors, really have to focus on making sure that they're acting appropriately in terms of the advice that they may want to give or recommendations they want to give, to be sure they put themselves in a place where they're either already registered and can do so, or fall neatly within one of the exclusions and exceptions and can document and evidence that in respect to all of that. I'll leave you with the notion that in many circumstances it may feel like as an issuer you're sort of in the middle. I think having everyone come to the table in the services they're providing for you and working together is really relevant and a key aspect of what this rule should practically affect. I think in between all of the interpretive wrangling and things that that'll go on and are necessary just to get the compliance program down, it's important for you to continue to focus on the services that you're being provided and looking at who's providing you that advice and understanding how the rule fits into that. I've said once or twice here, and I'll say again, for you to be an informed consumer continues to be a key component of what this all means. So I'll stop there, and I'll hand things back to Nick. I look forward to the question and answer period. Thank you for your time.
Thank you, Leo. So clearly firms need to be concerned about the content of their advice and then afterwards whether registration might be required. So it's clearly a more regulatory and compliance issues are important here. I'm going to turn it over to Rebecca. Rebecca, you have the floor, and just to be sure that you turn off your mute.
Thank you, Nick, and thank you, Pat, for inviting me to speak here. Leo has spent some time going over the Municipal Advisor Rule and some of the general concepts around it, and so I'd like to just discuss the Municipal Advisor Rule and the SEC's MCDC initiative from the perspective of the underwriter and the practicing municipal advisor, because Piper Jaffray serves both as an underwriter and a municipal advisor based on circumstances and the needs of our clients. As Leo started discussing, the Municipal Advisor Rule says that if advice is given to a municipal entity respecting the issuance of municipal securities or municipal financial products, that person can become a municipal advisor under law to a municipal entity with respect to that advice. And when an underwriter or a broker becomes a municipal advisor to the entity with respect to certain advice, they can't execute on a principal basis with respect to that advice. So a broker would not be able to sell the municipal entity securities for a municipal entity's bond proceeds portfolio if they become a municipal advisor in connection with that advice, nor could they underwrite bonds for that entity. So that's the practical consequence of the rule for the underwriter, and therefore the underwriter has incentive to seek to avoid being deemed a municipal advisor to avoid that fundamental conflict of interest. Advice is defined as a recommendation, but it also includes information that's tailored to an issuer's specific circumstances. Now, the SEC has carved out many types of communications that can occur between an underwriter, or broker, and a municipal entity. And these are generally communications that are not deemed to be a call to action or a recommendation. And some of these communications can include indications of hypothetical new issue pricing ranges, mathematical calculations of possible interest rate savings in the context of a refunding analysis, and examples of underwriting ideas that an underwriter has done for other clients. So as long as this information isn't tailored to an entity's specific circumstances, it's a permissible communication that doesn't trigger the MA rule. On the brokerage side of the business, your broker will be able to give you information respecting their inventory or price quotes for securities available for purchase or sale in the market, and current market prices and yields of an issuer's particular outstanding bonds. So these permissible conversations can occur, and there should be no constraint on the part of the underwriter or broker in terms of communicating with clients. Underwriters cannot, however, give advice without triggering this potential ban on underwriting, and that's mitigated by the presence of the creation by the SEC of 3 exceptions to the municipal advisor designation. The first one is the underwriter exception. So if this takes place, if an underwriter has become engaged by the issuer as an underwriter on a specific transaction, this exception allows an underwriter, pursuant to an engagement agreement, to give advice to a client without the participation of a municipal advisor. And it's evidenced by a number of sanctioned forms of engagement, one of which is a obviously formal engagement letter, also called a letter of intent. An underwriter can be appointed by the governing body pursuant to a resolution, or there could just be a simple exchange of emails in which the underwriter receives a positive affirmation from the issuer that they've been engaged as an underwriter. These engagements do not have to be binding, and they can be done or take place outside of the procurement process as long as there is a reasonable expectation that the issuer is going to use the underwriter to underwrite some bonds, which have been, by the way, specifically identified. So it's a limited exception, but it does provide the ability for you to engage your underwriter in a customary transaction the way you always have done, and does not require a binding contractual commitment. The second exemption which the SEC created is underwriters may give advice to a municipal entity in connection with or in response to an RFP. There are certain limitations around these RFPs that have to be reasonably competitive. But on the other hand, they can be posted to your website, and many issuers have taken that route. And that allows another avenue for municipal entities to receive ideas and information from their underwriting relationships. And then the third exception is the independent financial advisor, municipal advisor exception. This allows an underwriter to give advice after the municipal entity has made a representation to the underwriter that they have, in fact, hired an independent registered municipal advisor, and that they're relying on that entity. Again, this is many issuers have chosen to do this through a website posting or a written representation, fairly flexible way of discharging this obligation. Again, the municipal advisor rules do not create obligations and duties of issuers in this context. It's the underwriters that need to rely on an exception in order to continue to provide advice. So how is the rule working? I would say that underwriters have adapted to the rule. They still have flexibility, municipal entities still have flexibility to hire underwriters as underwriters and use the same firm as a financial advisor on separate transactions. Issuers have options for receiving ideas and information about municipal securities. Issuers may continue to receive more limited information without restrictions placed on underwriters. Issuers can use website postings for RFP or IRMA letters to continue to receive access to ideas from underwriters. The use of a municipal advisor is still optional, although underwriters are more restricted in terms of non-transaction related services outside of the context of an underwriting, and the exceptions are all issuer driven. So let me switch over to the MCDC initiative. I'm sure that's maybe more important to people right now as they struggle to figure out how to respond to the SEC's initiative here. The MCDC initiative is a program that the SEC created that allows issuers and underwriters to seek predetermined settlement terms related to inaccurate or misleading disclosures and offering statements relating to an issuer's continuing disclosure compliance. September 9th was the deadline for reporting for underwriters. Issuers have until December 1st. This program reflects a very aggressive intention on the SEC's part to use their available powers to force better disclosure in offering documents for municipal securities. There was an article in the Bond Buyer this morning about this program, and the architect of the program, Peter Chan, has made it publicly stated, he's not with the SEC anymore, but he's making it clear that the SEC intends to use their ability to enforce anti-fraud provisions under the federal securities laws to force better disclosure on other topics as well, and maybe possibly better pension disclosure, but that's a topic for another day. So how did underwriters respond to the MCDC initiative? The initiative was announced in March, and underwriters really had very little time to perform an extensive and difficult analysis on continuing disclosure history and statements and offering documents, and they would have to have gone back to all transactions in the last 5 years and look at reporting history for a 5-year period for each issue. Some underwriters had 3,200 offerings in that time period, so it was a very difficult process and required enormous resources from underwriters. Underwriters had to make materiality determinations without any SEC guidance. The data available to make materiality decisions was unreliable and unobtainable, and because of these factors, underwriter reports should not be expected to be consistent from firm to firm. In fact, we've heard that underwriters used different materiality determinations, did a different level of analysis, and there is no consistent application of methodologies in terms of what underwriters decided to report. But the SEC was happy to report repeatedly that many underwriters have participated in this program. In terms of suggestions, we went through this process. It was difficult. It was time-consuming, and I can give you some suggestions about what might be helpful to you as you look at your offerings and decide whether or not you're going to report them or how you're going to proceed. Obviously, you need to consult with your attorneys. But here are some of the things that we found out. I mean, issuers should really contact their underwriters and confirm whether they've included any of your deals on their reports. Underwriters should, they will have that information. They should be able to work with you on that. If an underwriter has in fact reported you, you really need to understand that underwriting and the facts surrounding the transaction, so you are either prepared to report or prepared to deal with the SEC later, because they've announced an intention to come knocking if issuers haven't reported their transactions. The data is difficult to find in terms of doing these audits. Filings were not supposed to have been filed to EMA after July 2009, but many filings continued to be filed on the pre-2009 NRMSRs. The only two pre-2009 NRMSRs that have information available is Disclosure USA and Bloomberg, and each of these data sources is problematic for different reasons. You should really focus on any internal records you may have that demonstrate that you did file reports on time. Many of these records we use to expunge a report that otherwise looked as though the issuer had fell down on their disclosure filing requirements because the data sources, the public data sources, were not always accurate and consistent with an issuer's own records. Another thing to check is to verify whether the information was made available on your website or through an OS posting of a subsequent offering. And if you decide to self-report, or if you think the underwriter should not report, you should contact your underwriter and discuss those facts with them. The reports that the underwriters filed, we understand that they can be amended, and we would certainly like to hear from clients if they decide to self-report or if they decide not to report, and they have facts that are helpful to us in deciding whether we could or should amend our reports. And finally, I just want to say about this MCDC initiative, an SEC enforcement proceeding is very stressful and serious, and any in-house counsel at a broker-dealer has gone through this process, and I would not recommend it to anyone. The MCDC initiative really gives issuers a way to avoid this. It sounds, it's a difficult decision to make, but the consequences could be considerably more serious. And from a personal perspective, I can say it's an enforcement proceeding is not something I wish anyone to have to deal with. And finally, while not every breach is material, I would again, give careful consideration to any decision not to report if you have facts that are problematic. The materiality standard obviously was the hardest thing for anybody to try to figure out. I think NAVL did a very good job. And again, I would encourage you to look at the Bondbuyer article today, in which I think the SEC is articulating a fairly reasonable standard of what transactions should be reported and what shouldn't be. So I'll turn it over to Bill, and thank you very much.
Okay. Rebecca, hi, thank you very much again for all the very insightful comments, suggestions. Certainly from your perspective, some of the challenges of meeting those requirements under the MCDC. Just from our perspective at Penn Turnpike, we've had a firm under contract for about 10 years now, assisting us with continuing disclosure requirements, and we've had disclosure counsel for about 4 years. So as a major issuer, we're certainly concerned about those issues. So thank you very much, and I'll turn it over to Bill Rhodes at Ballard Spahr, and Bill, just to be sure to take your phone off of mute.
Yeah, thanks, Pat, and thanks, Rebecca, and also Nick and the participants for joining in today. I just want to start by letting you know that a longer version of this presentation with much more detail, including actually showing you the format of what a MCDC self-reporting submission form looks like, is available through Pat's office to all the participants on this call. Let's see. Okay. So I wanted to start with just one quick step backward and point out that what is the basis for the MCDC initiative? This has been a long time brewing, to be honest, and both practitioners as well as a number of studies and reporters have found that for recent years, there has been relatively poor continuing disclosure compliance levels. The DPC study in 2011 found that at least a third of expected disclosures were never filed, and in fact, the reporting percentages seem to be declining in the later part of that 5-year period. Also, that more than half of issuers didn't file any annual disclosures for at least 1 or more years, and almost 20% didn't file for any of those years. In the SEC's enormous 2012 report on the municipal market that was covered sort of every aspect, they identified continuing disclosure practices as an area of concern. There was a GASB study and a couple others that are noted here, all of which said that reporting is slow, it's late, it's non-existent, and in general terms, compliance is poor. So the SEC began to take steps, and the first thing they did was bring the West Clark case. And the West Clark case really, it was the first action where they charged a municipal issuer with falsely claiming in an official statement that it was fully compliant with its disclosure obligations. They also charged an underwriter for not doing due diligence on this. But what happened was in 2007, they did an OS where they said we're fully compliant and relating to prior bond offerings. But in fact, West Clark School District Community Schools had not submitted any of the required annual reports or notices for a 2005 offering. So the SEC found a case that was pretty clear on almost complete non-compliance and brought the case. And I would point out that the Harrisburg case, enforcement case, had elements of this too, of non-compliance. So what is the MCDC? It's really the enforcement division of the SEC offering favorable settlement terms for issuers and underwriters who self-report. And they're saying we're going to continue to offer what we have been doing recently, which are the cease and desist proceedings, no requirement that you admit liability. There will be no financial penalties against issuers, although underwriters do have tiered financial penalties. But at the end of the day, what does a self-reporting issuer have to look forward to? And those are the typical remedial actions that the SEC has put in place in prior enforcement actions, which have been published. And those include establishing compliance policies and procedures. I would suggest that all of the participants on this call and any other frequent issuer of tax-exempt or taxable municipal bonds should already have these in place. And if they don't, they should be talking to their disclosure counsel or their bond counsel. And if they don't have a disclosure counsel, this may be a good reason to get one. But if they don't have it, you're going to have to put them in place. They're going to force you to comply with prior and existing continuing disclosure obligations. So in other words, reform your practices. They're going to expect you to cooperate with future SEC investigations. They want you to disclose the terms of your settlement with the SEC in all of your offering documents for the next 5 years. And they're going to want you to provide a compliance certificate to the SEC regarding the above actions 1 year from the date in which the C&D proceeding is instituted. Underwriters have a slightly different set of remedial actions, but they're very similar. So what would let's talk about what might self-reporting trigger. And the first issue that we have to confront is a recognition that individuals may not self-report through the MCDC initiative. The Enforcement Division will determine whether municipal officials should be subject to a separate SEC action on a case-by-case basis, and they will look at issues such as the individual's level of intent and cooperation with the SEC. It should be expected, because the SEC has essentially said so, that the remedies that it will seek for eligible issuers and underwriters who fail to report will be more severe than they would be under the MCDC, and that it will likely recommend financial penalties for those who don't self-report and are later found to have been in violation. Deadline for this, I think Rebecca mentioned it, the underwriters have already faced their deadline. If they did report you, hopefully they let you know, but your deadline to report your own noncompliance is coming up on December 1. So what does it not cover? It only covers continuing disclosure undertaking noncompliance. If your official statements have other misrepresentations in there, they're not covered by this. You can't clean up that problem by self-reporting other types of misrepresentations. As I pointed out, individuals are not covered, and so officials of issuers are not, don't get relief from this. And by the way, if you look at the more complete set of slides that are available to you that I've submitted, you'll see that on the form, all the key individuals are identified by name in the submissions to the SEC. An issuer who self-reports should expect that there's a chance that the SEC will make referral to other agencies, FINRA, DOJ, IRS, state regulators. They don't have to, there is no confidentiality in this between you as an issuer and the SEC. Self-reports may be viewed as admissions. They can't be withdrawn if settlement negotiations don't go the way you hoped. And they may serve as the basis for bondholder suits against issuers. And as I said, they may become the basis for other regulatory action. Certainly a self-reporting, because of the nature of the information, that it may well invite scrutiny of other disclosures or misrepresentations, and it could result in enforcement actions against the individuals. And of course, then you end up with situations where individual officers may be have conflicting interests from the issuer itself. So we have talked about materiality. The key question here is, what is material? And there's a well-established standard for determining materiality and whether a statement or omission under Rule 10b-5, which is the anti-fraud rule applying to offering documents in public finance, would be misleading as to a material fact. That's the key finding that would be the basis for a 10b-5 claim. And generally the idea is that a fact is material if there's a substantial likelihood that a reasonable investor would consider it important in deciding whether or not to invest. But remember, we're talking about, it's not a material fact that's stated. In this case, it's it's a statement that we have in the past complied when in fact you haven't. So there is this question of, what if we don't say anything and in our prior OSs, and I don't think that you're going to find any solace in that approach, because omitted information is considered material if there is a substantial likelihood that the disclosure of the omitted fact would have been viewed by the reasonable investor as having significantly altered the total mix of information made available. So the SEC has provided very little guidance on the types of misstatements that it considers material. We've heard that from Rebecca already. Absolutely true. The only thing we have heard from the SEC since the launch of MCDC was a case that they brought against Kings Canyon Joint Unified School District. Actually, the case began before MCDC was launched, and Kings Canyon asked to be allowed to go in under the new MCDC initiative, and they said that's fine. So the SEC order states that the district disclosed in 2010 that it had not failed to comply in all material specs. And that's a very common statement we see in OSs. But according to the SEC, they in fact did fail to provide some disclosure in 2008 and 2009 required by their existing agreements. There was no further details on the underlying facts, and the SEC has in fact been reluctant to provide any in public conferences or seminars, any additional guidance. why is this necessary? Why does the SEC think this is material? Well, their view is that the compliance history of an issuer is material to investors, and as they noted in the West Clark proceeding, there's a substantial likelihood that a reasonable investor determining whether to purchase the securities would attach importance to the school district's failure to comply with its prior continuing disclosure undertakings. And the SEC in both West Clark and Kings Canyon, those are the two cases I've mentioned, included a statement that it's important to enable the evaluation of continuing disclosure undertaking for the bonds by looking and getting a fair review of what they have done in the past as an indicator of future compliance. So NABL of the National Association of Bond Lawyers has been working on a materiality report, and they have provided and worked up a list of things that could be taken into consideration, factors that could be taken into consideration if for an issuer to determine whether some element of non-compliance might be in fact material. I would say that none of these constitute specific advice. Every one of these would be dependent on the facts and circumstances, but they are at least factors to consider. And I'll go down through these. The first is the importance of the information or the notice to be provided. Not all continuing disclosure information is of equal import. Clearly, a draw on a debt service reserve fund that evidenced, financial difficulties is probably significantly more important than a notice that a credit provider was substituted and the new credit provider has a comparable rating to the old one. The question is also, or one factor is the extent to which the information might have otherwise been public. Maybe it was on the issuer's website, or it was adequately covered in news media. Was the information available to institutional investors and rating agencies upon request, such that the information may have been taken into account in pricing or ratings on the bonds? Whether a misstatement related to an unreported failure to provide notice of a monoline bond insurer rating change during the tumultuous 2008-2009 period. The SEC has, I think, given some indications that if that is the extent of the noncompliance, that it's probably not material because of the widespread public understanding of the downgrades that were occurring by the bond insurers. Did the failures occur prior to the launch of EMMA? So was it in the first half of 2009? If so, the SEC has essentially acknowledged that the information available in the pre-EMMA period is in fact spotty, and it may not provide a sound basis or may not be clear as to whether or not information was not reported. Think about the length of any delay in filing a report. If it was just a couple days late, that might be considered more of a foot fault. But if it were months late, or there was a significant loss of time in which things changed dramatically between the time the notice should have been filed and when it was filed, that might be different. Was there some specific reason for the failure to file? Was there a significant pattern of noncompliance, or was this just an isolated incident? Did the issuer disclose several events but fail to disclose a single similar event? What was the length of time after the end of a fiscal year an annual report was undertaken to be filed? We see very different undertakings for filings of annual reports. They can be anywhere from as short as, I think, 120 days, which is pretty aggressive in this market, to as much as over 200 days. And if you had a 150-day covenant and you reported it 30 days late, is that as bad as if you had a 210-day covenant and you reported 60 days late? There may be distinctions within those. Did the primary failures occur early in the 5-year reporting period, and yet the issuer has shown that they've reformed their practices and been fully compliant since then? Were comparable municipal securities sold that disclose comparable noncompliance, and if so, is there in fact any evidence of whether the market pricing was impacted on these bonds or not? That will, if there is an enforcement action, I can assure you that there will be significant evidence submitted on this question. Subsequent to the reporting failures, did the issuer engage an independent dissemination agent? Maybe this is part of the reformed issuer story that, we've taken steps to make sure that we don't remain in noncompliance. Were the failures the result of just a single employee who's been replaced or properly trained, or is this a systemic problem of noncompliance at the issuer? And again, whether the issuers adopted continuing disclosure policies and procedures, undertaken training such that, again, past results are not necessarily indicative of future performance. This adoption of policies and procedures is clearly a mitigating factor from the SEC's point of view. So next steps, and this is where I'll wind up here. If you're going to report or not, you first should conduct an internal audit, and hopefully you already have. If you do find a misrep, you should definitely consult with counsel about whether it in fact is material, and if there's a potential material misrepresentation, you need to analyze possible consequences of self-reporting. And with that, I'll turn it back to you, Pat. Thanks.
Actually, Bill, hi, it's Nick, and
okay.
Thank you for a lot of good information, not a lot of guidance regarding materiality from the SEC, but you certainly have provided some good bullet points for issuers and others to consider. And before we drop here, we have obviously an issuer, Stan Quinnes from E470 Public Highway Authority, and can kind of describe some of the things that he's been, as an organization, they've been doing to comply with these requirements.
Good morning, everyone. I'm going to speak to the impact on issuers for both the MA rule and the MCDC initiative. Regarding the compliance with the rule, our financial advisor, Piper Jaffray, made it very easy for us. They provided a draft exemption letter that complied with the requirements by stating that we have an independent advisor, Piper Jaffray. I signed that letter and posted it to the investor relations page of our website. As underwriters excuse me, inquire about securing a copy of the letter, I direct them to the website for self-service. Now, the MCDC was a little more involved. At first, we thought it would be rather straightforward, as underwriters counsel on our last two bond deals had pointed out we had not complied to the letter with our continuing disclosure obligations by not disclosing that our bond insurer, MBIA, had been downgraded. Those facts were disclosed in E470's last two official statements, plus we deemed these events immaterial as everyone knew about them anyway. We thought we were good to go, and we're not planning on self-reporting. However, we were advised that disclosure in our official statements was not considered disclosure under the initiative, and that materiality had not yet been properly defined. We decided, with the advice of counsel and financial advisors, to do a little more legwork. First, we engaged Digital Assurance to conduct an internal audit to determine if there were any additional items of noncompliance. None were found. Next, we inquired to our sole lead underwriter of the deals falling in the time period under review whether they intended to report any exceptions to our compliance obligations. They stated they did not intend to report these immaterial omissions. Based on this, and that we also judged these to be immaterial, E470 does not plan on self-reporting. But we will certainly be paying closer attention to our obligations going forward, which is probably the point of this whole exercise anyway. Thank you.
Okay, Stan, thank you very much, and all the presenters. A lot of good information here, and not a lot of guidance here, but certainly you've made it easier for us to kind of understand the issues and to make sure that we are all kind of paying attention here, which is very important. I think we're pretty much out of time at the moment, but I'll turn it to Pat, and you can take it from there then.
Thank you, Nick, and thanks, Leo, Rebecca, Bill, and Stan for the excellent presentations. We do have a question addressed to Leo, and the question goes as follows. I'm familiar with the new MA rule, but not sure how this would affect the AE industry. if I'm working with a client that is looking at building a new toll facility and we're preparing T&R, O&M estimates, would I be able to tell my client at a high level that based on projected T&R, O&M, he could finance X amount of dollars? Note that I'm not telling my client how to finance, bonds, TIFIA, but rather the potential amount that they could finance for a capital project. The analogy is a realtor telling his client that based on income, he may be able to finance X amount of housing. The realtor is not saying get a 15-year mortgage or anything like that, just that the client may be able to finance a specific amount of money. So Leo?
Now. Yes, thank you, Pat. So I'll give you a brief response, and then I'll guide you to some additional context and detail. So in brief, it's a very imperative question that's being asked. It's something that accountants, engineers, deal team members are really focused on understanding entirely. There are two responses. One is the SEC has provided further interpretive guidance in the form of frequently asked questions. Acting as an engineer, acting as an accountant, acting as an attorney, these are all areas that they've focused in on. And I'll summarize it very simply by saying that the SEC has said as long as you're acting in a capacity as that professional, that's something that stays outside of the municipal advisor perspective. If it crosses over and you in fact are providing that type of financial advice, that type of municipal advice that is geared towards acting in a capacity as a municipal advisor, it clearly finds you then falling within that framework. So the regulatory response isn't very helpful from a practical perspective. So many folks on the engineering side, accounting side, et cetera, have looked to whether or not if there is a financial advisor involved that they in fact then look for potentially that IRMA letter as a evidence of excluding them from registration. There are also circumstances where RFPs may be issued, and some of the questions included in that RFP for you as an engineer may lead down that path to responding to that question. So in that analysis, it's something that if it's something in the normal, ordinary course of the services that you provide, I think it's something that passes. If it's something that goes beyond that, you should look for and try to evidence having that exclusion, that exemption in your pocket.
All right, Leo, thank you very much. Well, as Nick said, we are just about out of time. I want to say thank you to everybody for participating in today's webinar. Thanks especially to our facilitator, Nick Grieshaber, and to all the presenters, Leo, Rebecca, Bill, and Stan. You will receive a post-webinar survey by email when you receive it. We appreciate your completing the survey so we can continue to improve the quality of these webinars. And we invite you to look at ibtta.org/events on our website to register for our 2015 educational webinars and meetings. And look to the website tomorrow about this time, close of business tomorrow. We will post all of the presentations and the audio from today's webinar by close of business tomorrow. So thank you again for participating, and we look forward to seeing you at an upcoming IBTTA event. Thank you.